Good morning, all of you. I appreciate the opportunity to speak to you. Thank all the colleagues of Cremades&Calvo-Sotelo that have all worked hard to organize this interesting conference. Okay, let's start now with the first slide. As you can see by reading the first slide, we speak about arbitration clauses. The title of the session is How to Improve Efficiency on International Commercial Arbitration. This is the way we related to the title of the session. The fact that there is no efficiency if we cannot even initiate an arbitration proceeding because of an invalid arbitration clause. So our goal today is to draw your attention to the fact that in recent years often happen this kind of inefficiency with agency contracts that involves an agent that performed promotional activity of sales in the EU territory in favor of an extra EU principle. In fact, we simply must be aware that the validity of an arbitration clause can be at risk whenever an agent, disregarding the choice of exclusion arbitration, brings a claim in a European court. In such proceedings, we will see that the majority of the European court tend to invalidate arbitration clause and consequently make a decision on the merits of the case. Okay, we see, but why does this happen and which cases does this happen? To answer the first question, we need to consider that commercial agency contracts performed in the EU are governed by overriding mandatory provisions. So, bearing in mind this kind of rules, the majority of European courts tend not to refer parties to arbitration if their arbitration agreement contain an arbitration clause which makes it likely that those mandatory provisions will not be applied. Such judgments are severely criticized by scholars of arbitration on the following grounds. The fact that there's no reason, in principle, to consider disputes relating to overriding mandatory provisions inarbitrable, as long as there is no indication that arbitration is an inadequate forum. The fact that the question whether a particular provision is an overriding should not be confused with the question whether a dispute implicating overriding provisions are arbitrable. However, although such judgments is surely criticized, we need to know that it's a conclusion that it comes from the majority of the EU courts, which state that the overriding mandatory rules invalidate not only the choice of law clause, but also the choice of arbitration, the arbitration clause. So, before seeing what we can do to overcome these judgments, we need to answer the second question, that is, in which cases do the majority of EU courts deliver such decisions? The answer is when the court must decide on the rights granted to the agents by the Articles 17 and 18 of Directive. The Commercial Agents Directive was the first attempt at European harmonization of an entire type of contract. And with these articles set up a mandatory regime which give a commercial agent the right of compensation and indemnity payment if the principal terminates the contract for any reason. In this sense, we found the European Court of Justice with Ingemar decision as the leader have delivered this principle. Well, we may say that this is the area in which we find the most frequent source of conflict between a directive and arbitrational international commerce. And we can easily understand the reason, because if we consider that if an agent, if an indemnity payment is provided by an overriding mandatory provision, the agent will seek recognition of this right before a court, whenever he deems that ensuring this right will be difficult before an arbitration court. So in this way arises the conflict between the Commercial Agents Directive and international arbitrational commerce. In fact, we mentioned earlier that the majority of European courts invalidates choice of forum clauses, which exclude the application of overriding mandatory provision that state the right of indemnity for termination. Doing so, we find German and Belgian courts. We find also the Austrian Supreme Court that in 2017 concluded that there cannot remain doubt that the agent who mainly acted in the EU territory is entitled to a mandatory compensation claim in accordance with the articles of the directive, which have been transposed by the Austrian Agents Act. In that case, as the applicable law of New York does not offer a comparable regime, compensatory regime, the Austrian Supreme Court decided to invalidate the arbitration clause. And finally, we find the Italian Supreme Court that dealt with the question of the validity of an arbitration clause in 2016. With reference with an agency agreement between an US buyer and an Italian buyer agent. In that case, I'll talk in an obiter dictum. The Supreme Court affirmed that in that case, the arbitrational clause should be declared invalid, because the arbitration does not guarantee the application of the overriding mandatory provision. Well, with reference to the Italian situation, I am not an Italian seller like my colleague Luigi. In Italy, there is a particular situation that whenever we have an agent, personal physics, without an important organization, in that case, an arbitrational clause are never valid. So we need to consider this question. As I said, if there's a majority of the European court, there's who think different. And who think different is the French court that in 2008 affirmed the following principle that recognized the validity of an arbitration clauses regarding termination of agency contracts, even if provisions of public order might be applied to the merits of this case. But I find only this isolated position of French. So as attorneys, we cannot we have to consider the majority opinion of the European Court. So, for this reason, we have to think about a solution to overcome these judgments. And the solution is simple: is to draft an arbitration clause that may allow the court to conclude that in that arbitration trial, the mandatory provision will be applied. And so the proposed solution is, therefore, is to draft an arbitration clause where the parties state that arbitrators will apply the mandatory rules of the EU member state in which the agent has mainly conducted his business. So this is a simple solution. We need only to first explain to our clients that they must accept a little limitation of their choice of law applicable, but the benefit is to obtain an enforceable arbitral award. Well, I summarize a lot of my speech. I hope you have appreciated our presentation, and we thank you for attention.